The program started. First of all, I will say good evening or good afternoon or whatever. My name is Mark Mamagonian. I'm the Director of Academic Affairs for NASER, the National Association for Armenian Studies and Research. Thanks for joining us for another program. We have a couple of upcoming programs I want to mention. On Friday, October 8th, 2 days from now, please join NASER, the Armenian Film Foundation, and the Arat Askijian Museum for a work-in-progress presentation by Milena Oganessian entitled Ruben Mamoulian, an American Armenian theater and film director and artist, marking the 124th birthday of the great director. And really an unusual or perhaps all too rare opportunity to hear and learn more about this great figure in American cinema and stage. So please do join us for that. It's during the day on Friday, and information is on the NASER website. Next week, on Friday and Saturday, October 15th and 16th, there's a conference, Gender and Intersectionality in Post-Soviet Armenia, organized by the Zorian Institute and the UCLA Promise Armenian Institute, and co-sponsored by NASER and other organizations. Please join us for that. It's online and registration is required. Many other events are being planned and will be announced soon. And for those in the Boston and New Jersey areas, in addition to these scholarly webinars, NASER is pleased to be a co-sponsor of 2 in-person screenings of Jivan Avedissian's 2019 film, Gate to Heaven, which was set during the 2016 four-day war in Artsakh. These are in-person only, not online events. Imagine that. And will feature the director, Jivan Avedissian, in person. And that's Friday evening, October 8th at St. Leon Armenian Church in Fair Lawn, New Jersey, and Sunday, October 10th at West Newton Cinema in West Newton, Massachusetts. For ticket information, please go to the events page on the NASER website. And you can find it there. And if for some reason you can't find what you're looking for, send us an email and we'll get you the information. Finally, I want to mention that the book that lies behind tonight's program, Lawyers Beyond Borders by Maria Armoudian, is in our hands and can be purchased from the NASER bookstore online at naser.org. You can find it there. Please do check it out. We want to support our authors and scholars that we have the opportunity to hear from. So before I mute myself, I would like to invite Khachig Muradian, lecturer in Middle Eastern, South Asian, and African Studies at Columbia University, and the Armenian and Georgian area specialist at the Library of Congress, to join us and to introduce tonight's speaker. Khachig.
Thank you, Mark, and welcome everyone. I would like to welcome you all to our first event of the academic year on behalf of the Columbia University Armenian Center, as well as our co-sponsors, NASER, of course, with whom we have done a number of virtual events over the course of the past of last year and this year, as well as NASER has been a regular co-sponsor of our, in-person events at a time that seems at this point far in the past. We do hope that by the spring semester we will resume our in-person events and, in fact, organize a series of hybrid events, both in person and virtual. I would like to mention and thank again the Institute for the Study of Human Rights, our partner at Columbia University as well, and note that this particular lecture is co-sponsored by the NASER Gulbenkian series on contemporary Armenian issues. A couple of words about today's program. We're going to, after my introduction, Dr. Maria Armoudian is going to be speaking around 30-35 minutes, followed by a Q&A, which will be run by Mark Mamagonian. It is my pleasure to introduce Dr. Maria Armoudian, whose new book, just arrived. I believe we are the first, we have the privilege of being the first to be hosting a book event with her. Dr. Maria Armoudian is a senior lecturer at the University of Auckland in New Zealand and the host and producer of the radio program, The Scholars Circle. She's the author of 3 books. The book we're talking about, Lawyers Beyond Borders, Advancing International Human Rights Through Local Laws and Courts, as well as Kill the Messenger, the Media's Role in the Fate of the World, and Reporting from the Danger Zone, Frontline Journalists, Their Jobs, and an Increasingly Perilous Future. Dr. Armoudian has published widely on human rights, environmental politics, communication, and good governance. Before moving to Auckland, she served as a commissioner in the city of Los Angeles for 6 years and worked in the California State Legislature for 8 years, working on a variety of issues ranging from environmental sustainability to good government and corporate reform. In addition to her academic publications, her popular articles have been published in a long list of publications and newspapers, including the Washington Post, the Columbia Journalism Review, the New York Times Syndicate, the Los Angeles Times Syndicate, the New Zealand Herald, among others. So welcome again, and thank you again, Maria, for joining us. The virtual floor is yours.
Thank you so much. Hello, Parev. Let me also thank Nasser and the Gulbenkian Foundation and Mark Mamagonian and the Institute for the Study of Human Rights, Columbia University, where my dad did his postdoc. And most of all, Khachik Muradian, who's one of the best people I know and who organized this event. Thank you so much. It's such a great opportunity to be able to talk about this subject that I think is so important. Let me start by saying a little bit about the origins of the book. And then what I'll do is I'll talk about the main theses kind of in phases. And then I'll end with kind of what the current situation is. So the origins of the book, you know, I had gotten involved in politics, like on a practical level, when I learned about the kind of mass human rights abuses that were going on in the world, as well as the environmental destruction and the harm to animals and you know, just a lot of governance issues and corruption, that sort of a thing, because I wanted to make a difference. And so I ended up doing several things. I went to work for the California legislature. As Khachik said, I served as a commissioner in the city of LA. I also served on boards of nonprofit organizations and was involved in media. And what I found in that process was that it's extraordinarily hard to make a difference. Like, you know, I like to say that I really failed in some of the big legislative projects that I tried to put forward and in trying to, you know, halt violations or redress violations and that sort of thing legislatively. So I had gone back to grad school to study these things and to try to understand what had happened, why we were in this scenario, and why it's so hard to make a difference. And as Khachik mentioned, the first book I did, Kill the Messenger, looked at how the media could really exacerbate conflict and provoke genocide or peacemaking and promote human rights. I wrote that 10 years ago, and in that 10-year span, and it was partly written as a bit of a warning to what could happen if media, these kind of megaphones, didn't stop using these kind of what I called hate frames and blame frames. And things, sadly, progressively got worse, particularly in the United States, where, as you can tell from my accent, I am from, in terms of polarization and anger. And so this could bring about a despondency if you let it, right? And so when I found out about these advocates really making a difference against the odds and actually changing things for people, I wanted to know more. And as you probably know, I'm also the grandchild of genocide survivors. So I think we feel these things much more acutely We know what happened to our own people. We don't want this happening to anybody else. And so I was fascinated by this, what seemed like an impossibility. And even to the advocates' associates, it seemed like an impossibility. And so I started to dig into it more. So that's the background of the book. Most of the cases are really the least likely to succeed. These cases mostly happen in the United States. There were foreign plaintiffs, there were foreign defendants. The violations like torture and mass killings happened in foreign lands, and usually by powerful people who were supported by and protected by laws and militaries, and sometimes in partnerships with multinational corporations, which brings a whole other level of funding and finance and protection. So essentially what it is that the structures and conditions and systems are stacked up against the survivors and victims, and really unlikely for them to get any kind of recourse or redress. And they're among the really millions who remain without recourse and redress. But this book was really about agency. It was about the power of people doing things with the tools they had in the systems they had and bending them slightly and changing institutions just enough to make a difference, and about the power of ideas and creativity and the audacity to see possibility where there was not any before. So it is about political change. Now, the story starts in Paraguay and a military dictatorship, and with a particular doctor named Joel Filarga. And his son was tortured to death in Paraguay by Paraguayan military members. And he had been politically active in terms of denouncing the dictatorship. So they thought that this was a punishment for the doctor, even though the boy had not really done anything wrong. The long story made short here is that Dr. Filarga and his daughter, Dolly, tracked down the man who had ostensibly tortured Juanito to death. And they met Peter Weiss. And Peter Weiss at the time was a trademark lawyer who sort of moonlighted as a human rights lawyer. He had been steeped in human rights movement, but he was also steeped in the civil rights movement to the United States. And this marriage made for kind of a fascinating outcome, which was that the civil rights movement was making politics, changing politics, and making law through civil litigation, through suing people and holding them accountable and getting redress for their clients, ending segregation, at least the legal segregation for African Americans, and then taking that law that they had just created, or the politics that was getting developed from that, and applying it to another group of aggrieved people. So whether it was women or the impoverished or the accused, or later on LGBT. And so taking that foundation of law and then juxtaposing it onto another set of people and building a fabric of rights through the process. Well, Peter was also a Holocaust survivor, and he's still alive. By the way, he's in his 90s, and he sent me an email this morning saying he just got the book and was extremely happy with it, particularly about the idea of remaking rights. Because I have a chapter in there about, making, unmaking, and remaking rights. And so that's kind of the phase where he said he hoped we were, and so do I. So Peter's ideas were from the civil rights era, of course, but also from the human rights era, particularly this one of universal jurisdiction. And the idea behind universal jurisdiction is that some crimes are so heinous and so awful that they should be prosecuted anywhere. And as any lawyer a young lawyer, older lawyer, been through law school will tell you, jurisdiction is one of the major hurdles of getting a case heard. Well, Peter argued that these cases in which somebody's been tortured or there's been a genocide, these are under the banner of universal jurisdiction. And so he just needed a statute that would sort of articulate that so that he could sue a Paraguayan man in American courts for a wrong that was committed in Paraguay, where the plaintiffs were also Paraguayan. And he found this old statute. Doesn't remember where he found it, but it was in the first Judiciary Act of the United States. It essentially just said, it's called the Alien Tort Statute. It essentially just said that the courts had jurisdiction where an alien had suffered a wrong that was in violation of the law of nations. To him, that was universal jurisdiction. Said it right there, law of nations. And it worked. It worked on appeal. And they, even though they never collected, to my knowledge, on the $10+ million judgment, this was a moral victory, a symbolic victory. And Peña Irala, who had been in the United States at this point, was deported back to Paraguay. Well, guess what? What do civil rights lawyers do? They go, oh, look, here's a precedent. Why don't we build on it? Why don't we see what else, where else we can take that? So it spawned other ideas that built on this idea and went from the Paraguayan man to then a general in the Argentina army during the Dirty War who had disappeared people. And that case was successful. Then it was the Philippines and Marcos himself, who would normally be protected under head of state doctrines. And then that succeeded. Well, then that spawned Congress to go, whoa, this could be something that we take internationally. What if we pass law that supports the Alien Tort Statute, that expands it to also support people in our own country who need to sue abroad for something that happened abroad, because there was no law then. And then what if other countries then duplicated this in such a way that torturers would have nowhere to go, that their victims could not sue them? That was the idea at the time. Pretty aspirational. And they passed the Torture Victim Protection Act for that reason. Meanwhile, a young Ethiopian woman who'd been tortured in Ethiopia found refuge in Georgia. And she had gone to work in a hotel. And guess what? She ran right into the guy who had tortured her, working at the same hotel. She called Center for Constitutional Rights. They called the ACLU. They worked together and sued him and got him deported. They collected some of that judgment. She and her two compatriots who joined the lawsuit donated that money to the ACLU. But that case then led to an idea that a therapist had, which is, you know what? My clients who are torture victims can't recover if they run into their torturers. And if they can take action, then maybe that gives them back a piece of their agency. So he then, with these lawyers, created a nonprofit organization on the West Coast that was based on that very idea. The survivors, the torture survivors, could sue their torturers and in the process get a piece of their agency back. Well, if you take it just a little bit farther, then you go to Burma or Myanmar. And the next development came from 3 law students. And these law students were in Thailand, documenting human rights on a summer, research program. And they learned about a pipeline that was being built in Burma, at the time Burma, in which the indigenous people in the region were being enslaved to work on the pipeline. If they didn't, they could be shot or tortured. And they had all left their indigenous lands, gone to the Thai border, living in the jungles and hiding. And these law students eventually met them. And they thought, well, why can't we then sue the corporation that's involved in this? And so they did. And they filed a lawsuit. At the time, this was Unicow. It was a California corporation. It took years for this case to settle, but they enlisted other civil rights lawyers to get involved who felt like there were enough lawyers on all these other civil rights cases, so they were ready to explore and expand another area, which would be international human rights. That case settled for about $30 million and did go some way to redressing the survivors, built some programs in the region. And that organization, called Earth Rights International, then went on to try suing a foreign corporation which had upended the lives and violated the rights of the indigenous Ogani people in Nigeria. That ended up in the massive human rights abuses, 9 people hanged to death who had been leading a protest movement against these oil activities that were destroying the lands and harming the people. And so that ended up settling as well. Now, if we fast forward to today, what has happened today is that once the advocates started to try to stop the corporations from these violations, from getting involved with the regimes that were, usually dictatorships or some kind of authoritarian regime in which had no regard for the human rights of their people, then the fight started to get a little bit more difficult for the advocates. And I would say that the progress started to slow down then, but it also started to slow down with 9/11. And that was once the United States was in such a shock from the events of 9/11, it's like all of the human rights advancement took a really hard shock. And it took a very long time for any of it to get back online. And I don't think it's recovered. So what does that mean for human rights advocates? Some of them have gotten creative again. They've started working abroad. They've created NGOs with people in other countries. Germany is a key one because it has, and this again was Peter Weiss creating a nonprofit organization with his German counterparts called the European Center for Constitutional and Human Rights. And he chose Germany because he felt like its statutes were the strongest universal jurisdiction statutes. And they have taken cases all over Europe and are working with NGOs throughout the world, from the global South, from the global North, and then other advocates that came out of the CJA that the therapist Gerald Gray had founded. They're working all over the world with people in the global South and in the global North and in partnerships. And these are really the cross-border activities that we had not seen in full effect before. That looks like it's the future, given that the United States has sort of retracted and recoiled and become less amenable to protecting human rights, particularly those of people overseas. It's also been really difficult because the rights that had been so hard fought in the United States have also been pulled back. And so the lawyers who had been doubling as both human rights lawyers and civil rights lawyers have found themselves having to sort of focus their brain power back into their own countries quite a lot. So let me just say a couple of things as an Armenian too about Artsakh, because this is an area that, and I recently wrote a piece for the Armenian Weekly that suggested this could be something that Armenians can pursue, and the Artsakhis who have suffered both from the loss of their loved ones, from the torture that some of them have had to endure, and also from the loss of indigenous lands, is this idea of universal jurisdiction. The question is, where do you go to file a lawsuit? In what forum? Who are the advocates that you use? And but this idea of universal jurisdiction, and the courts that are accepting these cases are really important to potentially advance the rights that have been retracted for the people of Artsakh and Armenians in this case, which is very fresh right now, and there needs to be action. I understand there are a couple of actions that are underway. I don't have the details yet, but this is something that I think needs to happen now. And so why don't I stop there and see if there are some questions? And thank you so much.
Maria, while you're on it, since probably not everyone watching has had a chance to read the piece you wrote in the weekly, I mean, as I'm sure you know, as an Armenian and as someone who studies these issues, there's a tremendous level of maybe cynicism, given our history towards the efficacy of these kinds of international courts or legal actions. Why could this potentially work or be different than other occasions in the past where seemingly we've run into walls?
Look, it might or it might not be. The point is that there is a creative way to put together a case. I'm not a lawyer, I'm a political scientist, so I study the kind of change in politics. But it requires these ideas that are put together in ways with the facts, right? And sometimes you have to draw way back. Sometimes you have to draw forward. And that's one of the things these lawyers have done. And the other thing is that they don't give up. And I'm going to talk just a minute about the Unicow case, because there's a whole chapter on that in the book. And this is the one involving the Burmese torture survivors and the slavery survivors. You know, when they first filed their lawsuit, it took, I think that case, I don't know how many years it actually took to get a settlement. But the courts, you know, kicked it out. And so the lawyers appealed. And then they got kicked out again, and the lawyers appealed. And they appealed on different grounds. So even when, in some cases, there's one that's going on right now in which the Achenese people in Indonesia, right, have been trying to get redress from Exxon, partly while their chairman had been appointed the Secretary of State of the United States, and here they are in federal court, right? But at a certain point, even the Supreme Court said you can't use the Alien Tort Statute for these anymore. But these lawyers were thinking and looking for other avenues. There must be another way. There must be another way. They ended up using state law in both of these cases, state common law, which means, for example, instead of calling it torture, you might call it battery. Instead of calling it, genocide, it might be a wrongful death type of a suit. And so they become, these are civil cases in the United States. What would it take for somebody from Karabakh to be able to do a case in the United States, where you'd have to be able to serve the person that you are suing? Probably be good if they had assets. If you wanted to get some monetary out of them, if in fact you could serve them papers, that's certainly can make it so that they could use something like the Torture Victim Protection Act. And so these are ways just in the United States courts. There are also other courts that accept these kinds of cases, human rights courts in Europe, some of them international, some of them national and local. that all need to be explored. And again, each of these would have different advocates who would understand them better. It's just the point is that this has to be done in a way that is creative and that mixes and matches international law with the local law and with the old and classic with the new. And look, there are many instruments that can be used for this. And I really think it should be. I think that these are violations that cannot and should not go unanswered. Even if there is a loss, it's really important to move forward.
Thank you. I should have said this at the beginning, and I neglected to do so. If you'd like to ask a question, please do use the Q&A rather than the chat, so everything is all in one place. If you want to say hi or great job, Maria, or congratulations in the chat, and you certainly should.
Should I look at the chat?
Please use the chat for
I'll
that.
look at it
But
in a little
I
bit.
know a couple of questions have come in the chat as well, and I will try to not forget that they are there. But please do use the Q&A. That's my little procedural speech. Maria, what is your assessment of the current state of global human rights, particularly practiced locally across borders, considering the weakening of rules-based world order? A good question.
I think it's in really bad shape. But that doesn't mean that it has to stay that way. You know, there are even some scholars at this point who are giving up on rights. And I'm not one of those scholars. I think you don't throw the baby out with the bathwater. I think individual rights as well as collective rights need to be examined and need to be shored up. All of these things are ideas. Rights are not gifts, as Charles Epps said. These are things that are hard fought and hard won, and they take a mass type of activity. And if increasingly people give up on them, then they are gone. Look, I think we're not in a great place at the moment, but it doesn't mean it has to stay that way. Politics is always changing. And what changes politics are people. We change it. We change it through our communication. We change it through our ideas and through our creativity and through our networks and building on these things, using institutions or building new ones. So even if we are in a really scary place, which I think it's a little bit scary, I think you take what you have and you build on it with what you can, the tools that you have, and you don't give up, you keep going.
Yeah, and isn't there a certain element of use it or lose it, that if these institutions and structures that have been created aren't used, then they will be used even less and eventually just be abandoned?
Absolutely. Yes, absolutely. Including fighting for, ensuring that rights like the, and the conventions that were there to protect us, the Convention Against Torture, the Convention Against Genocide. Yes, we have to use them.
Thank you. Next question is, can you please comment on the prosecution of journalists and free speech in Armenia going on now, the current situation?
I don't know if I can, because I don't know that I have followed that in Armenia particularly. I know that that is going on in Azerbaijan, but I had not been following the prosecution of journalists in Armenia, so I'm sorry that I can't talk about that.
That's okay. Thank you. Next question. One of the muted factors that makes the Without Borders framework functional is that the principles, 1, don't deal with human rights engagement as transactional, but use a solidarity framework, and 2, coalesce with others who may not be directly involved with their specific issue. Can you say a little about to what degree these factors are universal and necessary or not?
Okay, Mark, say that one more time.
Yes. Let me just read it again, rather than my trying to restate it and lose the thread. One of the factors that makes the Without Borders framework functional is that the principles, 1, don't deal with human rights engagement as transactional, but rather use a solidarity framework, and 2, coalesce with others who may not be directly involved with their specific issue.
Yes.
Can you speak about the degree to which these factors are universal and necessary or not?
I would argue the solidarity is really important, and that cross-border solidarity is extraordinarily important. It's a task of persuasion, so it's a task of framing. What has happened in the U.S. with the loss of rights has been that the counter ideas have won. And so if we want the solidarity to have the last say with rights, it really has to supersede these counter ideas. Counter ideas, whether they're sovereignty, national sovereignty, or whether they are state secrets or whatever they happen to be, the protection of these things. In the US, the latest one has been extraterritoriality, but these should all be subservient to fundamental human rights. And so, yes, the solidarity is important, and that is part of the persuasion that the advocates have taken on. It's also a values and a normative battle. Cass Sunstein talks about norm entrepreneurs and people who advance certain norms. Well, you can see that both in the rights advocates advancing these norms, but you can also see it in people who advance the counter ones. Donald Trump is a prime example. If you look at what he's done, part of what he's done is change the norms of the United States. And some of that has been that there are no facts and there is no rule of law, and it doesn't apply to certain people. Well, that's something that we can't let stand if we want rights to continue to exist. And that does take a solidarity, a cross-border solidarity. I would completely agree with that. I hope I answered that. Did I answer all of it?
I think that gets at it. Yeah, I hope the asker feels as well.
If not, they can do part two.
To follow up, that's true. Can you talk about bridges that occur between international labor organizations and their use of the frames you're working on?
A little bit, but not as much. I know that one of the things that has happened is that in the United States, labor unions have been, because my book centers first and foremost on the United States and the movement there, the labor lawyers saw the connection, and that is what connected them first to Burma and then on to other places. So while labor has been slowly torn to bits in the United States, it has enabled all kinds of things that we abhor in the United States too, and in New Zealand, where I am sitting at the moment, including child slavery and adult slavery, and the things that we would never let happen in the United States legally. It does happen in the United States under the radar. And so there has been some solidarity, but it hasn't been very strong to my understanding, that the labor movement has not been as well connected on these matters in order to advance labor rights. And there are the anti-slavery groups, for example, but they are not necessarily working with the labor movement in the United States.
We have a question here. What might be the cost of this type of legal action in the United States? And I don't know if that means literally the monetary cost or cost in other senses, but perhaps you can speak to either or
Yeah.
both.
They're expensive. They're expensive lawsuits. A lot of times the nonprofit organizations that take on the lawsuits partner with large firms who can underwrite the costs and get their sort of prerequisite pro bono work handled in the meantime. That can be a little bit difficult in some instances if the pro bono law firm, if you're suing an individual, it almost doesn't matter what law firm works as on the pro bono side. But if you're suing a corporation, it starts to limit because of conflicts of interest that arise in those law firms. There are also civil rights lawyers who take on these cases either for free as a side project because they believe in it, and they work with their students in their clinics and that sort of a thing, and they double as something else, a law professor or working in another area of law. And then the others also work on contingency. So if there is a settlement or there is a judgment and they're able to collect, then they get a portion of those fees. But I know that at least one of the civil rights law firms that lost a case, they lost upwards of $1 million in that case. So they can be really expensive and really painful if you lose.
And I think you talked about this in your Armenian Weekly piece, if not in the book. The difficulty, even if getting a successful judgment, of collecting.
Yeah.
What does one do if one gets a multi-million-dollar verdict in your favor, but there are no mechanisms for collecting?
Yeah, it sort of depends on who your defendant is, right? So if there are assets in the country where you sued, then you might have a way of collecting. So there was a case in which the defendant happened to have won the lottery and had some assets. And so they were able to collect. In the case of the corporations, they obviously have a lot of money and people were able to collect. They're harder to sue now because of the Supreme Court's decisions in some of these cases. And then again, like if you're talking about, I think these the Pandora Papers that just came out.
Yes.
I think these are going to be a treasure trove of knowing where those assets are. And in particular, I noticed there was one that dealt with Azerbaijan. And,
Enormous, yes.
And so there may be assets there that do make for a nice judgment if in fact you can win a case. So yes, it depends where the assets are. It depends on how much they have. The problem is if it's an individual, they get deported, they don't have assets in the country where you sued, then you don't have the mechanism. But sometimes, maybe you can enjoin something down in, depending on if you can do a follow-up. Sometimes these cases, like I think I mentioned in that Armenian Weekly piece also, the journalist Marie Colvin's family who sued the Republic of Syria, it's really unlikely they're going to be able to get a lot of collection of that. But you know what? All of the fact finding that comes out of discovery of doing a lawsuit ends up then going into helping other cases when you can share them with that other court. And so then in another place, in another time, those assets become possibly collectible as well.
Oh, this is a question that's maybe it's slightly outside of the scope of your book, but I'm going to ask it anyway because I think it's an interesting question for you. Why do you think the gross social divisions have arisen fueled by populist regimes, given the current level of transparency about the nefarious intent behind these strongmen? Is this willful denial or sheer greed and fear-based?
I am going to answer that question to the best of my ability, but please ask me one more time because I want to make sure I've heard it.
Yes. Why do you think the gross social divisions have arisen fueled by populist regimes, given the current level of transparency about the nefarious intent behind these strongmen? Is this willful denial or sheer greed and fear-based? I'm not sure whose denial and greed, but nevertheless.
So this would kind of fall more into my previous work than into this particular book. But look, I studied political communication and the effects that political communication have on audiences. And of course, it's different for different people. I mean, nobody receives the same message in the exact same way as the person next to them. But there's certain frameworks that evoke emotions. And one of them is the fear framework that this person mentioned. There's a certain frame that brings that fear out, and that brings the resentment out, or that brings hatred out towards a group. And it rings true even if it's not. And those scholars who have actually looked at brain scans from these messages can actually see what happens when you say transparency, but you get a true fact that comes up against that frame. And if somebody believes that frame, they find a way to push it away, the fact away, because it causes a cognitive dissonance. Their world is organized around a particular way of seeing things, in particular kind of emotion. And people get addicted to their own emotions and frameworks so that nothing else can come in. I think the strongman authoritarian is the easiest, simplest, us versus them, good versus evil, requires no integrity, no thinking, no complexity, no gray areas. And so it's what some people want to adopt simply because of that, because it's easy. And the other stuff, it comes in like a morass and chaotic and hard to take in. So I think that's part of it. I think it's an easy way to see the world, us versus them. And I do think the fear is part of it. And, you know, greed is also about security. So it's also fear-based. Given all the different kinds of media now, people just want to go to the ones they trust. And they isolate themselves within these little silos. And the other things they hear, push it out.
True. Well, then we'll go to the next question. Turkey as a NATO member and still seemingly favored by the State Department is virtually ignored in its basic violations of law. It's reached a point, the questioner writes, where Greece and France are making a separate defense deal now. How to deal with this? Through lobbying efforts, through lawsuits? Is it necessarily an either or can the two work hand in hand, I would add?
I would say all of the above. Look, you know, I think personally, I think Turkey's time has come. And so, and given what's going on with Azerbaijan and what is this sort of neo-Ottoman Empire building, and some people are recognizing that and are concerned about that, I think the time has come to do all of the above and to look at it from all angles, lawsuits included and lobbying included, and at every institutional level. And, you know, might I add, getting people elected and getting people into positions where they can make a difference, getting people in positions of power. Look, the United States changed in terms of its human rights agenda because of who got into power, as well as the messages in the media. I would say the messages in the media came in tandem with that, the divisive ones, but then increasingly, people who got into power were not rights oriented. And that's part of what changed the fabric, because they had the decision-making power. So we have to put back in people who hold the same values about human life into those positions, and concerns about, you know, security in those important matters for the future.
Next question is, how have U.S. courts responded to American lawyers using the law to go after foreign entities who may or may not have been in the U.S.? Is this supported in the courts? Has it been supported by Congress? Has it been supported by the executive branch?
It's been a mixed bag. As I mentioned, the case against Syria, the courts ruled in favor of the Colvin family against the Syrian Republic. It sort of depends on the country and what its behavior is, what the wrong is. They are no longer protected by sovereignty laws in the United States, the courts, when they act in ways using things like torture and terror and that kind of a thing. That there are statutes in place that say that. So again, it depends what the country is, what they have done. Are they an ally? Because often what happens in the court is that if a lawsuit is filed, the executive branch will weigh in and say, you know, we have a concern about this. Now, in some cases, the lawsuit stretches out long enough that the administration changes. And in one or two scenarios, I think one was regarding the Philippines. When they first filed the lawsuit, maybe it was Indonesia. I'm sorry, this was the Aceh case, Doe versus Exxon, where the executive branch came in and expressed concern about a lawsuit in this because of the effects it might have on the relationship with Indonesia. That started to shift, you know, and then the next administration sometimes does and sometimes doesn't continue on that path. Same can be said in the war on terror, in which there were cases against private contractors that had been involved in the torture of innocent people in most cases who had gotten caught up in the war on terror. And the administration had come in and opposed those lawsuits initially, but in the last few cases, they stood down and they let the lawsuits go ahead against contractors. That includes the two psychologists who designed the enhanced interrogation program that the CIA had in place. And they ended up settling with two survivors and the family of one of the victims who actually died in a black site.
I mean, we've seen in Armenian cases, or at least in one notable Armenian case in this country, where the executive branch took a strong stand against, I guess it was the Movsesian case in California, and the executive branch did not want its foreign policy prerogative impinged upon, as it understood it anyway. Is this not a danger in many of these cases where the executive says, no, this is not a question of law, it's a question of foreign policy prerogative?
Absolutely. That, and sometimes it matters and sometimes it doesn't. Sometimes and sometimes they will stand back, and you can, it just depends on timing. So much of it is about timing and what is on the table at the moment, what is the concern at the moment. And sometimes the court still says, sorry, I know this is your concern. This was the case in Russell versus Bush, in which Guantanamo detainees had no rights, no habeas rights, couldn't get a fair trial, were in detention without knowing what they were charged with. Nobody even knew who was in that prison. But the Supreme Court finally said, they do have to have a trial. And even though Congress and the executive branch tried to circumvent that by creating these military courts at the time, the US Supreme Court still at that time, again, it's timing, said, no, it's not good enough. And so it just is a matter of finding those avenues to the extent that you can. Sometimes you can't, but sometimes you can, and you've got to give it a shot.
Question: what thoughts do you have for pursuing cultural heritage preservation and protection in the courts, since cultural rights are not yet defined as human rights?
I think I haven't looked into this yet, but I was thinking to look into the rights of Indigenous people and the declarations around that, to see what those areas are, because I think cultural heritage might fall into that. It's probably the hardest one, and because life and limb are obviously at the top priority, but I think I would start to look there as well, and then and see what other scenarios have happened historically in which cultural heritage was then protected and given back. I know some of that's going on again right now. I just saw some of that also in the latest Pandora Papers, tracing the artwork, and people are having to start giving it back.
And the question is, though, then, who is defined as an indigenous group? Maybe this is a different topic for a different night, but
Yeah, probably is. Well, I think people who have lived on a land for thousands of years, that would probably qualify as indigenous.
Is there a specific
A legal definition?
international
I
law
don't
definition?
know. It's worth looking. It's worth looking.
Okay, another question. How can the Republic of Armenia exercise universal jurisdiction in an effort to hold Azerbaijan and or Turkey accountable in regards to particular instances which were obvious violations of international law, the Geneva Convention, and basic human rights?
Look, I think some of this is underway to some degree already. People are starting to think about that. It's like what I was talking about a little bit earlier, which is that you have to have the statute that enables universal jurisdiction. In the United States, you've got the Torture Victim Protection Act. And so if there is a torture survivor who can identify the torturer, for example, and can serve that person papers, there's a possible pathway. Again, now not being a lawyer, but this is something worth talking with the lawyer about, including some of these, nonprofit organizations that do this kind of work. Europe, particularly Germany, but others also have universal jurisdiction statutes. And you have to check and see who is eligible to use those statutes. In some cases, like every country is different. Like in Spain, for example, the person who is hurt has to be a Spaniard. It wasn't always the case. They changed it recently for their universal jurisdiction statute. But each one of these countries has a different approach. Then there are courts of human rights. There are human rights courts. There are these other avenues that are beyond the individual country types of actions that you can take. I would go talk with advocates in each of these places and see what their ideas are. And if there is a possibility of serving the torturer or the person who killed in a court of law, and if those laws exist. And look, the United States took the lead, and other countries have followed. There are these possibilities. Lots of NGOs throughout the United States that are helping. Lots of NGOs throughout the world that are helping in some of these. Trial International, Redress, European Center for Constitutional and Human Rights, all worth exploring and talking with the various people there to see how and where a case can be brought.
Is there stronger support for this sort of action is it more strongly supported in the EU than it is in the US or in other regions or other blocs than it is in the US? Or is the US, in fact, in the lead?
It's different in every place. So the European system is not the same as the American system, in which they run administrative law rather than, it's not, it's a completely different system, not common laws. And they have prosecutors that actually take on the crimes as well, but also using universal jurisdiction. Mm-hmm. It just varies from country to country. The US I started there because I'm from there, and I saw this kind of boomerang happening in a way that I never thought was possible, and that somebody had made possible. Just through creative juxtaposition of facts and laws and classic and new. ideas. It's still possible individual to individual, and sometimes suing a country, but it's hard. It can happen in the US, it can happen in Europe, it can happen in the Court of Human Rights. You just have to find the way to make the facts and the laws fit.
Sounds so simple.
Look, good lawyers should be able to do this. Good, I'm just a political scientist, but watching these lawyers, I'm quite inspired by how they have advanced a cause in this way in a time when everybody thought it wasn't possible. So they started to make change until people got into power that didn't like the change. So it's kind of a parallel universe here where you just have to keep going forward and you can't stop.
I think we heard something nice said about lawyers there, and maybe that's where we should stop, because that's such an unusual occurrence. And I know there are some lawyers watching, and they must be delighted to hear positive things said about their profession in public.
I'm a big fan of good lawyers.
Absolutely, very, very important. Well, let me point out once again then that we would encourage people to pick up a copy of Maria's book, whether it's from the Nasser bookstore or elsewhere, and read what she has to say about this, because of course you can't cover everything in one presentation, and there's a lot more in the book that you need to read to appreciate in its totality. So let me say thank you to the audience and for your excellent questions and thought-provoking comments and questions. And of course, to our co-sponsors, the Columbia University Armenian Center, the Institute for the Study of Human Rights at Columbia, and the Nasser Kalust Gulbenkian Foundation series on contemporary Armenian issues. Thank you to Khachig for introducing and for helping put this together. He's disappeared, but we know he's still out there somewhere. And above all, thank you, Maria, for an illuminating presentation.
Thank you
for
so much.
A nice conversation, and for answering all these intriguing questions.
Thank you very, very much.
Thank you. Have a good night, or good day in your case, which is tomorrow. So
I'll tell you how it turns out.
Good luck with that.
Hey, leave the comments up for a little while so I can read them all.
Sure will. Good night, everyone.